Hi, folks. I'm Denise Howell. And next up on This Week in Law, we've got a Notre Dame twofer today. My co-host, Matt Curtis, and his professor, Mark McKenna, are both here, as well as my other co-host, Mike Keys. We're going to discuss online terms of service and brands versus white supremacists, Forever 21 versus Gucci, Star Trek versus Seussian mashups, and much more. Please join us next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by CashFly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, Matt Curtis, and Mike Keys. Episode 396, recorded August 18th, 2017. The possibilities are endless. This episode of This Week in Law is brought to you by Felix Gray. Give your eyes the break they deserve. Felix Gray glasses filter blue light and reduce eye strain without the ugly yellow tint distortion of other computer glasses. Go to felixgrayglasses.com/TWiL to try a pair today. Hi, folks. I'm Denise Howell, and you're joining us for This Week in Law. We're so excited that you've joined us this week. We have a wonderful panel of folks to talk about the latest developments in case law and legislation and policy having to do with technology law, as we do every week. This week, we're joined, very happy to be joined by a guest who is a law professor at University of Notre Dame's Law School, Mark McKenna. Mark, welcome to the show.
Thank you for having me.
It's wonderful to have you. Mark has the distinction of having authored the amicus brief that was cited by Justice Breyer in his dissent to the Star Athletica decision. We're going to talk a bit about Star Athletica and what has become of it today. He also teaches intellectual property law, privacy law, torts, and various other things, I assume, Mark, as well, at Notre Dame.
That's right. Yeah, mostly across the IP areas, but yes, that's right.
Wonderful. And we're welcoming back to the show my co-host, Mike Keys, who is a partner at the Dorsey firm in Seattle. Hi, Mike.
Hi, Denise. Great to be with you, and great to have Professor McKenna with us today. This is going to be a great show.
I know. I'm looking forward to it. We're also going to have, hopefully, our other co-host, Matt Curtis, who is actually one of Professor McKenna's students, or has been one of Professor McKenna's students at Notre Dame. Matt's running just a little bit late, so we're hoping to add him into the show on the fly here as we go. We're not going to let that hold us up too much, and we're going to jump right into it. There's been a lot going on this week, and we're going to start by talking about terms of service. This has been a great week to see companies enforcing their terms of service, invoking their terms of service in the wake of the protests and the aftermath of the protests in Charlottesville, Virginia, which started last Friday night, right after we did our last show. So we have seen in the aftermath of all of that a flurry of companies who have decided that various individuals or organizations would not be permitted to use their platforms in the way that they had been using it. The term has been coined this week. I think it was coined this week. I've never heard the term before, called no platforming, where tech companies, people who would be the platforms for hosting a website or hosting a social media account, for example, even hosting music, hosting financial interests. Various and sundry companies have looked to their terms of service to say, if this is the message that you are using our services for, if this is what you're about, targeting various white supremacist groups and or content, that does not pass for us. It's against either our community guidelines or our terms of service, and we're not going to help you get out the message that you're getting out. So there's been a long laundry list of companies who have gotten on board with this, some different nuances to what we've seen happen this week. We've seen Facebook that decided to delete links to one attack on Heather Heyer, I believe it was, saying unkind and scurrilous things about her. Facebook took it upon itself under its terms of service to delete that post unless it was prefaced by some discussion of, why the post, some sort of commentary. I think I'm not sure how fine-grained Facebook went into what sort of commentary had to accompany the post if it was going to be shared. But it did want to prevent the post from just proliferating without some sort of commentary as to its scurrilous nature accompanying the post. Other things that we've seen, interesting from Cloudflare, which terminated the Daily Stormer, a white supremacist website that was very active in the wake and probably during the protests and probably leading up to the protests. And it invoked, not that it had any particular terms of service provision that would have barred that kind of speech or opinion or what have you. It invoked its right to terminate users of their network at their sole discretion, which is part of their terms of service. And what they've written is the tipping point for us was making this decision was that the team behind Daily Stormer made the claim that we were secretly supporters of their ideology. Cloudflare decided that was a bridge too far for it. Various other companies include PayPal and Apple, Spotify, as I mentioned, even getting to musical platforms, Snapchat, really a lot of folks deciding to enforce their terms of service, to preclude themselves from being a platform for white supremacy. And my take on it all, and I'm very interested to hear from our panel on this, is they are completely in the right under their terms of service to be able to rule their fiefdoms as they see fit. They are private companies. They are not government organizations. I'll put an asterisk there because we have had some discussions on the show recently having to do with when something like Twitter or another social network can turn into a public forum. But that's not the default state that these things exist in. So they're not compelled by the First Amendment to support any particular kind of speech or not, and they are perfectly fine under the law to decide what sort of content they want on their sites or not. That's my take and understanding, but I will definitely defer to our law professor guest on this and see if he has any nuance we can bring to this discussion.
Yeah, so I mean, it's a fascinating topic. It's obviously going to keep coming up, and as a lot of this stuff keeps unfolding. So I think you're basically right. As a matter of law, that insofar as the terms of service predated the activities that lead to the takedown, and they're reasonably clear that courts generally just treat that as a contract issue, and you're subject to the terms of use when you decide to use the site. The only complaint you would be is if they were arbitrarily enforcing them, or they were not acting consistently with what the terms of use require. I do think, though, your last comment sort of points to a bigger issue, which is, I think, in many ways precisely what the net neutrality debate is about, which is whether or not Facebook is a public forum. There's some significant analogies there to things like public utilities, where Facebook and some other of the platforms maybe are such dominant players in their area that they aren't that much different than public utilities, in the sense that you can only get your electricity from one place, or you can only get social media from one place. And so, the big policy question, if you take it away from this specific instance, is do we want do we want to allow in general? And then if we do, at what point in the network architecture do we want to allow companies that have, very substantial control over access to the internet to make content-based decisions about what's allowed to be up there and how it's allowed to be used? And I think that's actually the Cloudflare post that you put a little segment up of was actually very thoughtful about that. I think saying, we made this decision, but now we need to tell you why it's really dangerous, because when you start engaging in this kind of discrimination, it invites more of that and invites, lots more content sort of distinction. So obviously, many people are, and I am certainly sympathetic to the particular decision they made here, but it does invite a sort of bigger conversation about who does the censoring of what goes on the internet at what point in the architecture.
Well, and it can become at some point hazardous for them under Section 230 of the Communications Decency Act, can't it? Because
it can if it.
Yeah,
I'm sorry.
Explain why it can, please.
Well, so for someone like Facebook, certainly that's true. I mean, it can, insofar as you're talking about a platform that allows users to put information up there, and that's true, obviously, of most of the things you would conventionally describe as platforms here. I think some of those. So if you take different of the players are acting differently in different places, but I think there's a fair number of them that are pretty actively policing. So they'd be outside of the Section 230 guidelines, but a lot of them have tried very hard not to get themselves in that position, precisely by saying, we're basically hands off here. I don't think you could actually describe Facebook and Twitter as being completely hands off, because they do have terms of use policies that they do enforce and take down certain things. In fact, in some cases, people are kind of critical of that because they're often implemented through AI that doesn't differentiate between here's a post that's up there and violating the terms of use because it's saying things that they're worried about, and others who are posting them precisely to criticize them or to engage with them in some other way. And so I think that's the line that all of these platforms are trying to walk.
Right. And we should explain for people who don't practice in that area. We talk about Section 230 a lot, but just in case this is the first time you've ever heard of it, how it functions and what it does. It protects service providers for many of the activities, not all, but many of the activities of users on a site like a social media platform or a web hosting platform. The users who are doing the objectionable act are held accountable, but the site is not under Section 230 unless, as Mark said, they're doing a lot of, they're very involved in what's going into it. They're doing a lot of editorial and policing as to what's going to stay and what's going to go, and they have a role in what content is being distributed on their platform. So it is a difficult line to walk, Mike, as a practical matter. In advising companies, you and I as lawyers want to be able to tell our clients, yes, of course, consult with us as we help you craft your terms of service, and we will make sure that you're able to rule your fiefdom as you want to. But at some point, we also have to tell them, how far they can go and still invoke the protections of Section 230. Do you see a lot of tension there?
There certainly can be. I was really pleased to see all of this proactive activity by all these technology companies. Obviously, there's no place for this type of speech in our society. So great to see these companies banding together and taking this action. But of course, there is an inherent tension there. I mean, once you start banning this type of speech, which I obviously applaud, and I think most people do, it does raise the question of ultimately where would that end up? So there are some difficult lines to be drawn, but I think in this case, it's obviously a very clear-cut case that was I think well thought out, well executed by a lot of these companies.
Yep, I tend to agree with you. Mark, any further thoughts before we move on to other topics?
No, just to say that I think that this issue is not going to go away. This is only going to get more difficult. I mean, I think one of the motivating reasons for the reaction of many of these platforms is that a lot of them are giving some serious consideration to the extent to which their platforms were used in ways during the election and then post-election as platforms for the circulation of fake news. And I mean that not in the way the president uses the term, but but things that are actually fake. And I think
Real
Facebook in particular, actual fake news, right? There's Facebook in particular, I think, is looking in the mirror and, trying to figure out what role it played, its platform should play in policing the legitimacy of news, given that not Facebook itself necessarily, but social media is the mechanism through which many people receive a lot of the information that they receive now.
Right. I'm just sort of tossing around an idea in my head, and I'm wondering what you guys think about it, that the impact of more and more companies deciding not to be a platform for objectionable content. It doesn't mean that those people are going to go away, right? Just like people who are determined to torrent things don't go away. They find other ways to do what they want to do. And I'm wondering just, what the impact of that is. Driving white supremacists to the dark web doesn't seem a terrible thing to me, but I just am trying to play out the consequences in my own mind, and I'm wondering if anything occurs to either of you. Mark?
So I think that's the right question to ask. I mean, I think if you think that circulation of this kind of material is likely to increase its impact and recruit more people into it, then making it more difficult to find and to get online has some benefits, right? On the other hand, it depends also on the assumptions you make about the technological sophistication of the people who are in these groups and whether they are capable of finding or creating other outlets for this. I mean, it certainly is for the majority of people in the world a pretty significant setback if you can't get anyone to host your site and you can't use Facebook and Twitter. Makes it much harder to get your information circulated. For a small subset of people who are pretty technologically sophisticated, that probably won't be. But then if the effect of that is it reduces the information flow to that small group of people, it's a pretty significant effect.
Mike, do you think that there's a Streisand effect kind of impact here that needs to be taken into account too? I'd certainly never heard of the Daily Stormer before this week.
Yeah, I think that's probably right. To your initial question about, what ultimate effect is this going to have? I think there was an article in today's rundown about how, look, there's ways that people can get their racist invective out there using code terms and other things that may evade content filters and other technological measures. So, I think there's unfortunately this is going to be a recurring problem, as Professor McKenna said. I think there's going to have to be, to the extent we want to drive this out of the web or elsewhere, there's going to have to be some sort of action taken where people are somehow punished or penalized for this type of conduct. I have no idea if something like this would work, but I was thinking about it in preparation for the show today. What if some of these technological companies, what if they amended their terms of service to provide for some sort of liquidated damages against people that are use their platform for hate speech or other very objectionable speech? I don't know if something like that would be enforceable, but it would be interesting to see a development like that come into play and see if that ultimately had an effect in any way on curbing people's activity, at least online, in terms of spreading racist comments and invective. But curious if either one of you think that something like that is even plausible or feasible.
Right. Professor McKenna, you don't teach contracts, it doesn't sound like, but do you have a thought on that?
Yeah, I don't teach contracts. I mean, I do think, though, that kind of stuff is probably coming. I mean, I think we're going to see some of these platforms get more creative about trying to drive stuff away. I just think that it's interesting. It's going to create some interesting bedfellows here, because I think that many of those companies have been pretty strong proponents of net neutrality. And the phraseology that they usually use there is non-discriminatory carrying of information. I don't think this is what they had in mind, obviously, but they meant mostly things like you shouldn't be able to decide, AT&T shouldn't be able to decide that it's going to stream its own content faster than it streams Netflix content. But, as soon as you get into the territory where you start saying, well, we're going to allow this kind of material and not other kinds of material, it's an interesting contrast with the sort of otherwise the other sorts of positions that many of these companies have taken on these sort of things. And it certainly raises the stakes of whether we think of these things as public utilities or as having any sort of market power, if not only are they able to sort of effectively keep things off their site, but they're actually punishing people, in some monetary way for doing it too. I don't know. I guess I don't have a strong view on like whether they would be legal, but I do think it would push on a lot of other things that are currently floating around anyway.
Right. The other thing that was sort of in the back of my mind all week as I was seeing these stories roll through is sort of a parallel to the realm of copyright infringement and the DMCA here. And of course, Section 230 of the Communications Decency Act does sort of have some parallels and plays similar roles in that it provides a safe harbor to sites. But the thing that prompted me to wonder about this was a really interesting article, and I'm hoping people will check it out. You can check it out and everything that we discussed today and have used to prepare for and brainstorm for the show at tagpacker.com/user/thisweekinlaw. We are on episode 396 this week. And the article in particular that I am thinking of now, I need to scroll back down to, is titled "Tech is Not Winning the Battle Against White Supremacy." So it tees up the fact that it's great that all these companies are taking these steps, and then it does a deep dive. This is from TechCrunch into how much white supremacist content is still available on various platforms, and gives examples of things it was very readily able to pull out. And as I was reading this, I thought of, the MPAA combing through YouTube and finding all the various things that YouTube is trying to make sure, the infringing material YouTube tries to make sure it doesn't host, but is there anyway. The ramifications are not quite the same. I don't know. Do you think, Mark, that somebody might try, if there's enough of this material that TechCrunch was able to find, for example, that remains in place and remains available despite all these steps that the platforms are taking, despite this no platforming movement, if it's still there, would someone come after one of these companies under hate crime laws, for example?
I find that a little bit hard to imagine. I think that so one thing that's misleading about the headline, I think, is that to say that they're not winning the battle. I think, to be fair, you'd have to say that until recently they weren't even trying to win the battle, right? They were. There was very little effort to exclude anything, and so the fact that they haven't yet succeeded in doing it, it seems to me like an unfair thing to say. I mean, if you want to criticize them, I think it would be for getting a very late start on making any attempt to do any of these things. I would say, though, I think one of the lessons of the file sharing episodes is that there's no such thing as elimination. You're never going to completely get this stuff off the web. And so if TechCrunch, spend some time finding it and they can still find it, and that's an indictment, I think that's probably not the right standard. You're never going to completely get rid of it. I think the question is, can you drive it down to a smaller level and make it more difficult for people to find it? And I think that it's worth keeping in mind that obviously none of the views that have been expressed on these websites and none of the stuff that's coming out in these rallies is new. Those groups have existed forever in the United States, and we've never effectively gotten rid of them. But the internet has made it easier for those people to spread that information. It was, you used to have to get together at somebody's house to do it and talk to each other or write some things in a magazine or a newspaper and circulate. And the internet has helped with recruitment. And I think these platforms are now having a real conversation for the first time about the extent to which they want to be implicated in that.
All right. Well, let's see if we can cobble together an MCLE passphrase from that discussion. Get off of my site seems like a good one. We put these phrases into the show to help you, our viewers and listeners, who may be attorneys or other professionals who wish to seek continuing education credit in your field for watching or listening to the show. For attorneys, we have a chart that we put together some time ago, and I should mention that the chart was a volunteer effort cobbled together by one of our interns. And we really, really appreciate your help if it is going out of date. If you notice that any of the links we've provided there to forms that you might use to apply for credit or what have you are not current for your state, please let us know. We want to keep that information as current as we can for you. And we put these phrases in to the show so that you can demonstrate that you watched or listened. Our first one for this episode will be "Get off of my site." I'm going to write that down right now. And also should let you know, in recent days, one thing, again, I am never going to pretend to be able to interpret your various jurisdictions' CLE requirements for you. I leave that to the lawyers who listen to the show and wish to seek credit. But one thing that sort of came to my attention is that having an interactive component of a video discussion of law is important to some of the compliance bodies. So please be aware, I mention it usually at the end of the show that you should join us live and use our chat, but I'm going to mention it in the course of the CLE discussion too. Be aware of what rules govern you and what sort of credit you might want to seek. And if being involved, being able to ask questions of the panelists, et cetera, and put your own 2 cents in is important to your compliance body, please join us in chat because that will help you out, I hope. That's at irc.twit.tv, and it plays along with us throughout the show. So we hope to see you in there. Next, we're going to move on to a topic that is near and dear to both Mike and Mark's hearts, trademark law. So we've managed to move to trademark law, but not move out of Charleston just yet. Sorry, not Charleston, Charlottesville. Getting my CHAR Southern cities confused. Charlottesville. There, although nothing that happened in Charlottesville was a laughing matter whatsoever, there is some sort of sad irony, I guess, that one of the injured parties for everything that went down last weekend and in the aftermath were various tiki torch manufacturers who did not want in any way, shape, or form to be associated with what happened in Charlottesville. So this brings up the question for our trademark experts here. When your brand has been co-opted in a way like this, what can or should you do? Mike?
Yeah, so, the Tiki Torch people were in a very difficult situation here because their brand was being tarnished as a result of it being used by all of these white supremacists during the Charlottesville protests. So, our trademark laws really are calibrated towards unfair competition and infringement by another party, meaning that you're using somebody else's trademark or service mark in order to promote your goods or services in the context of a commercial transaction. So even though these folks were using the Tiki Torch, they weren't using it in the traditional trademark sense for purposes of triggering a claim for trademark infringement or unfair competition. So really, and I'd love to hear Professor McKenna's thoughts on this as well, but really what that leaves these brands with is kind of a PR campaign. You need to go out and make sure, as Tiki did immediately, said, look, we're not affiliated with this. We find it abhorrent, and this kind of speech has no place for us, and we don't support it as a company. I think that's exactly the right move. Engaging a PR campaign specialist or other folks is always a useful step. I think we see some very recent examples of this being successful. You may recall during Trump's campaign, there was Donald Trump Jr. tweeted a picture of Skittles and equated that to the Syrian refugee problem. And, Skittles, or Wrigley's rather, the owner of the Skittles brand, came out right away and said, look, we think that this is a completely improper, inappropriate analogy. Skittles are candy, refugees are people, and we don't think anything else needs to be said. So, I think the key is getting out in front of these issues quickly and taking decisive action to distance the brand from these particular comments. I think that's really the main thing that brands can do.
Right. Further to your Skittles or candy point there, even if the brand of the Tiki Torch manufacturer weren't being directly tarnished, did they have some sort of legal foot to stand on by saying, Tiki Torches aren't about this. They're about having a barbecue in your yard or on the beach. And this is, why we create these things. And this is the image that we have crafted our brand to convey. And I suppose they can't control if somebody decides to do otherwise with a product that is capable of it. But it echoes that Skittles type point, don't you think?
Yeah, it does. I mean, I'm very sympathetic as having represented a lot of brand owners over the years about these problems associated with a company's products or services. At the same time, though, you don't have all controlling power over how a trademark is going to be used.
Right.
Once you put it out into the marketplace, people are free to use it to an extent. And our trademark laws and other laws don't ultimately give you control over all manner of uses of a trademark. But, like I said, from my perspective, the most important thing is a really well-crafted, thought-out PR campaign that can be launched immediately is really the best antidote here.
Well, before we get Professor Mark McKenna's thoughts on all this, I want to welcome on to the show Matt Curtis, one of Professor Mark McKenna's students at Notre Dame and our co-host here at This Week in Law. Hi, Matt. Great to have you.
Hi, everybody. Sorry for being a little late, and I'm having a little technical difficulty, so we're just going to do audio today.
Great. Wonderful to have you in whatever shape or form, Matt. Glad you could jump on with us. We'll come to you in just a second, but right now, Mark, why don't you give us your take on the dilemma of the Tiki Torch companies?
Yeah, so I think I agree almost entirely. I mean, I think it's a good reminder that trademark law isn't built to deal with these kind of circumstances, and in general, I think it shouldn't be, because the same thing that's happening here in a more extreme way is when it happens when somebody wears Burberry clothing that the Burberry company doesn't want associated with them. And in general, trademark law is not oriented to prevent all uses that affect the meaning of a brand. I think it's actually a good reminder that of the limits of trademark law, that brands are largely creatures that live outside at least outside of the perfect control of the brand owners, because they require social meaning that's engaged in by and co-created by consumers and by the rest of society. And so that does leave the brand owners vulnerable to these sort of things. And in the main, that's a good thing, but it exposes them in the extreme to things like this. And so I think I agree that it's the best response to it is to speak. In brand owners, many brand owners, maybe not in this particular example because it's so extreme, but they're usually very reluctant to get involved in anything that looks at all political, because losing any block of your customers is a big problem. So, I have a colleague who teaches at St. John's named Jeremy Sheff, who wrote a nice paper about this at one point. And, one of the examples that people talk about regularly is Michael Jordan at one point reputed to have said in response to a question about why he isn't more socially active is that Republicans buy sneakers too, right? And so brand owners are really loath to get into these sort of situations where they have to police who's using or who's engaging with their brands until they get to a circumstance like this that's so extreme that they feel like they have to say something and or risk having their brand look like they're complicit in it. So it's a tricky situation. It's one that brand owners are pretty regularly having to confront, and most clients want to have more control over the brands and the law actually affords them. I would say there's one example out there that where maybe there actually is some legal action that can be taken, and I think it's not the tiki torch example, but it would be. You might have seen the stories about some of these folks down in Charlottesville using shields with what looked like homemade versions of the Detroit Red Wings logo placed on them, and what at least as I understand the facts right, which I might not, but what might differentiate that example is that those people were having those shields made with those logos, in which case it looks a little bit more like, not perfectly like, but a little bit more like a conventional trademark case where you're enforcing the rights in your mark against somebody else who's using it on and in connection with goods and services, as opposed to just buying your legitimate products, your tiki torches, and using them in ways you wish they wouldn't. And so that might be a circumstance where there's at least some conceivable legal response. But in the main, I think brand owners' recourse here is to speak.
Right. That's a great distinction. Thanks for pointing that out. Matt, do you have anything you want to add to this discussion about tikis in Charlottesville?
No, I think that from a business perspective, that all makes sense what Mark and Mike had to contribute.
Yeah, I think so too. Thank you so much for covering that so nicely for us, gentlemen. Let's move on. Let's finally leave Charlottesville and move to the mall and talk about Forever 21 and Gucci, who are in the latest high-profile trademark battle that may have some relationship. I'm curious to see what you guys think to the decision in Star Athletica, which we're going to discuss shortly on the show. But hear what Forever 21 is doing that Gucci objects to is using stripes. So that's kind of why I think Star Athletica comes into play, because there we had stripes and chevrons. Gucci has some distinctive stripes that identify its products, and the same sort of blue, red, blue pattern stripe has shown up on a number of cheaper, more accessible Forever 21 goods, including, and this is featured in the complaint in the action, on a jacket that looks very, very much not just the use of the stripes, but the whole jacket looks like a Gucci jacket, a silver jacket with then the stripes featured at the sleeves. So the two of them are engaged in litigation now, where in Star Athletica we had stripes and chevrons on cheerleading uniforms. Here we have stripes on various and sundry clothing, and it's Gucci saying you can't be using those stripes. They are connoting that the person may be wearing a Gucci product when in fact they bought it for $15 at your store. So Mark, what do you think about all this?
So, I mean, this is probably obvious, but I should state it just to be clear. So the doctrinal difference obviously is that the Star Athletica case is a copyright case. This is a trademark case. What they have in common, though, is, and I guess I would state the connection like this, is that at least prior to Star Athletica, which may have upset this understanding, but the general view was that you couldn't really very effectively use copyright law to protect features of articles of clothing. You could protect surface ornamentation, maybe, and you could protect patterns, but that features of the clothing themselves were pretty difficult to use copyright for. And one, I think, unintended but actual consequence of that was to push more fashion cases into trademark law and have them be litigated on that basis. And so, Gucci has a couple of registrations of this stripe pattern. I think it highlights more than one, but among the things it highlights are the significant differences between trademark law applying to features of products and to its more traditional subject matter, things like word marks and logos. And that when you get into trademark law policing features of products, it invites a whole bunch of boundary questions about how do you want trademark law deciding which features, which might be attractive to consumers for reasons other than their source indication, but because they just like stripes or they like stripes that are on the end of sleeves. Is trademark law really a good vehicle to be protecting them? And if it is, how would trademark law think about the scope of the rights that are attached there, because obviously, as you're in the images you put up there before, some of these are very basic patterns. It's just 3 stripes with different colors, and how much originality do you really need, and how much distance between the Gucci's use and someone else's use would you have to have in order to deem them non-infringing? Those are questions that trademark law really kind of has a hard time with.
Yep, I would think that it does. Mike, what are your thoughts?
No, I agree with that for sure. I guess with the additional thought that when it comes to trademarks, of course, as Professor McKenna pointed out, there's a pretty significant gulf difference in doctrines here between copyright and trademark. Copyright deals with whether 2 designs or 2 works of authorship are substantially similar, and it's divorced to a large extent from how consumers perceive or whether consumers perceive if there's a connection between the 2 companies. Contrast that with trademarks, which is all about whether consumers perceive that there's an affiliation, association, or connection between the 2 companies. So to the extent that a company is using a basic pattern, such as stripes, and they have developed goodwill associated with that particular source identifier, then they can claim trademark protection. You have, for example, Adidas that uses, has the 3 stripes on its shoes, and it is very very proactive in enforcing its marks against third parties. So in my mind, this will really come down to whether they're able to establish rights not only in this stripe design, but whether consumers are going to be confused and think that there's an affiliation or association between the 2 companies.
Yeah, right. I agree with that as a distinction. That Adidas is a nice contrast, especially because I would have described them as sort of notorious in their enforcement, in that Adidas has sued people for using 4 stripes and 2 stripes and different kinds of stripes and things that don't even look like stripes that much, because once you start giving people rights in basic things like 3 stripes, they sort of think their rights are pretty broad. And in general, so there's in a recent case that's actually against Forever 21. Forever 21 basically blasted them in a fairly recent brief and saying, we have no idea what is the trademark that Adidas seeks to enforce and what's the scope, because here are all the examples of the things they claim are infringing, and they run the gamut from a stripe to many stripes, different color stripes, different locations on products. And so I think that's the challenge, is that figuring out what's the unit of comparison here, and how do you do that when you're talking about a feature of a product? And then in the cases that involve features of products where courts, in my judgment, do it well, they have to account for all of that context and the context in which consumers are likely to see the clothing. And no one's going to see a piece of clothing in a Forever 21 store and think it's a Gucci dress, right? But sometimes courts are tempted just to do the comparison and say, that stripe looks like that stripe, and divorced of the context in which they'll see them. And so I think that all of that stuff is in play whenever you're talking about a product configuration case, not to mention which you have to account for the fact that even though the stripes might have source indication in some context, a bunch of consumers might want them for reasons that don't relate to that. So this, if you think about the case that Louboutin filed against Yves Saint Laurent about the red sole, right? So Christian Louboutin simultaneously has pretty significant consumer recognition of the red sole. Yves Saint Laurent was making a monochromatic red shoe, which included not just a red sole, but a red upper. Louboutin thought that was infringing because it had a red sole, notwithstanding the fact that it was an entirely red shoe. And I think plausibly, Yves Saint Laurent was able to say, look, people want red shoes because they're red and they match things, not just because they come from Louboutin. And when you let somebody lock up basic designs, you run the risk of eliminating competition for things that people want for non-source reasons, even if they also happen to sometimes attribute them to a source.
Hey, Matt, anything you want to contribute to this discussion of Forever 21 and Gucci?
No, I'm curious about what Mark and Mike think about the business case for going after for filing something like this, even though you're not 100% sure. So is there like an advantage for Louis Vuitton to file this against Forever 21, even if there's a 20% chance they're going to win?
So this is Gucci. So Louis Vuitton files everything, no matter. Louis Vuitton loses all of its trademark cases, and it keeps filing them over and over again. In Gucci's case, Gucci actually won a case against Guess a number of years ago that involved this stripe pattern, among other things. So I mean, I'll defer here on the question of sort of the strategy. My sense, though, is that sometimes people file these cases in part to clarify the scope of their own rights. So they want to get a sense of how far they can push them. Sometimes they file them because they think the defendant's not likely to fight it all the way through. And so even if there's only a 20% chance of winning, they might get what they want out of the case, even if by virtue of it not going all the way to a judgment. Sometimes they file it just because they feel like they have to defend their territory, even if they're unlikely to win. So I think it's a complicated set of considerations.
All right. Mike Keyes, any final thoughts on Forever 21 and Gucci?
Nothing further from my perspective at this point.
Okay. Mark, anything else?
Nope.
All right. Matt, I think you're good, yeah? All right, then let us, before we leave the topic of trademark and trade secret cases, plunge back into the procedural details of a trade secrets case that we've covered on the show before, the case between Waymo and Uber involving their trade secrets and allegations that a former Waymo employee, head of Uber's self-driving car project now, Anthony Lewandowski, had downloaded more than 14,000 documents, Google documents that contain trade secrets about self-driving cars before he left his job at Google-owned Waymo and went to Uber. The interesting discovery dispute that they are in now is that Lewandowski has not participated in the case. They haven't up until now been able to tell what he took with him and what he gave to Uber or might have given to Uber or not, because he's not talking. He invoked the Fifth Amendment and says, he may have liability there, and so that's it. They haven't been able to get at that information. Well, it turns out now, and the parties are wrangling about it, that there was a discovery firm, a document and digital device imaging firm called Epic, EPIQ, that Morrison and Forster, on behalf of Uber, had been using all along to do their discovery in this case. And they learned that Epic has a complete copy, a complete image of Lewandowski's hard drive, which presumably have at least some of the documents in question on it. So the parties are wrangling about who has what's on the hard drive, who's in trouble here, whether the lawyers are in trouble for not disclosing this, whether Uber even knew that the lawyers had the documents. It's all kind of a big mess. The point made by Uber's attorney seems to be that it was just because their discovery firm had something doesn't necessarily mean that they had it, and also that whatever was on there was just a sliver of the relevant documents in the case. So there's no determination here yet as to what they're going to do about this. But it's just a hot issue in the case right now, and it could have a damaging impact for the Uber side of the equation if it's found by the judge that they had these documents that have been at issue the whole time and sought the whole time and didn't disclose them. And that's something that can be told to the jury and that can reflect negatively on Uber, perhaps. So just wondering, Mark, if you've been paying attention to this case and now the discovery brouhaha they're involved in.
Yeah, I mean, paying close attention to the case as a sort of trade secret matter, I think this is a case that could wind up being a really big deal. One benefit of not doing day-to-day litigation is avoiding the discovery disputes, which are, so I will certainly defer to Mike on that question. I mean, obviously, there's in every modern trade secret case, the question of how you find out who knew what at what point is crucial, and figuring out where you get that information from. And so, setting aside whether anybody hit anything here, I think there are some really interesting questions in some of these cases about the extent to which you ought to be able to get access to information through third parties that have access to servers and things. So, I mean, imagine, people are using a Gmail version of email. Should you be able to compel Google to produce someone's entire, email history when they're not a party to the case, and they're not, and someone has just used that as their ordinary email service? I think those are interesting kinds of questions that are going to keep coming up.
Right, and you're teaching privacy law this fall, so I assume ECPA is going to come up in the discussion at some point.
I think so. It'll be, it's obviously a very significant set of questions. I mean, there are people, I think, who advocate that basically anything you disclose to a third party, you don't have any interest in anymore. It's so if you use, and I think that in our world where internet intermediaries basically look at everything you do, scanning your email for everything, that's a pretty extreme view that would basically give you no level of privacy expectation in pretty much anything you do on a computer.
Right, and I just caught myself talking in acronyms again for the benefit of anyone who doesn't know what ECPA is. It is the Electronic Communications Privacy Act. It's old and in need of reform, and I believe
one could say that about most areas. Yeah.
Right. Didn't we just a few weeks back on the show talk about the fact that there might be legislation in the works, or perhaps is legislation in the works to reform it and help it out on that front? I believe that's the case. We'd have to go back and check the EFF site because they track that pretty closely. Mike, tell us about the discovery dispute here between Uber and Waymo.
Yeah, I mean, I've been following the case a bit. I'm actually sympathetic. I don't know all the ins and outs of this particular discovery dispute, but God knows that the amount of documents and amount of discovery that's at issue in a case like this is massive, and it takes a small army of folks to adequately manage it. So, it's obviously a very important issue in any case, any big case these days. There's a massive amount of digital discovery, and you have outside consultants, and this particular outside consultant I've actually worked with before. They're excellent. So, it's a difficult issue. You got to keep your arms around it. You got to have kind of a discovery master that's tasked internally with just making sure that everything is taken care of here, and that the right hand knows what the left hand is doing. I'm not saying that that didn't happen here, but it just kind of reinforces for me the importance of really staying on top of e-discovery. It can be quite a headache in any case of significance.
Right. So fact check, or just sort of compare your guess to my guess as to what happens next here. It seems like, because you've got a defendant who's invoked the Fifth, or not a defendant, he's not even a party, right. A third party who has invoked the Fifth and is not even involved in this litigation. But these are his documents. His drive was imaged. Does Uber even have the ability to produce them, since the Fifth Amendment is protecting this guy's interests? And it seems to me that the court's going to have to handle this very delicately, and that certainly everyone wants to get at these documents in this case, but maybe they'd have to be under review to the judge and the judge's staff, and the judge's staff would have to determine whether this was implicating Lewandowski's Fifth Amendment rights or not to produce them. Does that kind of sound like how it might go?
So that's probably a bit above my pay grade. But I mean, that's certainly I agree with you that this sounds like a tricky situation. But if Lewandowski if he's invoked the Fifth Amendment right against self-incrimination, I don't know that extends to a third party. If that third party would somehow would have to comply with that as well. I don't know the answer to that, but it certainly raises an interesting, very interesting question.
Right, and I guess the drive was in Uber's possession because Lewandowski was Uber's employee. That's where he went. That's what this whole case is about. And the whole case is about whether what was on that drive were trade secrets that should not have been shared. So his invocation of the Fifth Amendment in something that's not his own personal property is fairly interesting as well here. Matt, anything that this raises in your mind?
Yeah, the other thing is that he sold his original company to Uber. And so if he had it while he was there, it seems like they would also be able to discover that. It seems like if it was on the premises of either company, it's kind of hard to, or on their servers or hard drives, it seems like it'd be hard to say that it's his personal property.
Right. Fascinating. Well, we will continue to follow the case and keep you apprised of developments that we think are noteworthy. We're going to get to talking about the Star Athletica case from the Supreme Court, as we've been mentioning a few times during the show. But before we do, and now I have to find the proper tab. You should see how many tabs I have open in my browser right there. Now, there we go. Before we get to Star Athletica, we're going to thank a new sponsor for this episode of This Week in Law, and that's Felix Gray. I am wearing Felix Gray right now. Felix Gray makes glasses that protect me and protect you and protect all of us who look at screens all day long, whether it's your computer screen or your phone screen. You might even be listening to this show to get away from your screens for a bit. And you all know that eye rub moment when your eyes feel dry and fatigued and you have a headache, and it's because you're getting strain. Maybe your vision goes blurry. Because computer screens and phone screens are hard on our eyes. Well, here's where Felix Gray comes in. Felix Gray's lenses are specially designed to filter blue light and eliminate glare, which many of us know are the two culprits behind digital eye strain. Too much blue light from your computer and phone screen can lead to eye strain and make it difficult to focus. Felix Gray glasses have blue light filtering material embedded into the lens, so they remain effective without that ugly yellow tint or color distortion of other computer glasses. I think they're really stylish. I am wearing the Faraday model of frames. If you go to Felix Gray, if you go to their website, you'll see that they have a whole selection of frames for you to look at. If you want to hear more about this whole dangers of blue light issue, go to felixgrayglasses.com/TWiL. And you'll find many more details there that will bring you up to speed. What I have found, I've been wearing these around for about a week now, and they make a number of different options, not just the frames, but how the lenses work. The ones I'm wearing at the moment are no magnification whatsoever. They just cut the glare. But me being, a solidly middle-aged person, I definitely need a little magnification in my life. So they make magnifications ranging from, you can do just a tiny bit of magnification, 0.25% magnification. If you're somebody who doesn't really need reading glasses for any other reason, but you're fixed on your screen all day long, that little bit of magnification just gives your eyes a little bit more relief along with the glare cutting. Or if you're like me and you use readers all the time for reading things, they've got magnification from 1% to 2.5%. So here's how they come. I'll do a little unboxing for you. If you can see, this is their main box. And then they come with a nice case and a cleaning cloth, very handy. And the glasses, these are the magnified ones. I had my husband try out both as well. He loves them too. He loves them so much that we actually immediately bought him another pair. These are the two that I was provided to test out so I could talk about them to you. But we immediately ran in and purchased a pair for my husband off the website. I believe he went with the Nash style frames. because he really liked him too. So don't worry about it if you can't pick out a particular frame or a particular magnification that you think is going to be dead on for you. All orders include free shipping and free returns, so there's no risk at all to try them out. Do try them out, because once you've got them on your face, you're going to go, whoa, what was I doing? Why was I not wearing these before? They feel so much better. So I encourage you, try one pair. If it doesn't work, try another until you've got that perfect fit and feel for you. Give your eyes the break they deserve. Go to felixgrayglasses.com/TWiL today to try a pair of Felix Gray computer glasses and discover a smarter way to work. That's felixgrayglasses.com/TWiL. Thank you so much, Felix Gray, for the new specs and for your support of This Week in Law. All right, moving on, we're going to turn to a big copyright decision out of the Supreme Court this year, which we've talked about before, but something new has actually happened. That's the Star Athletica copyright decision. So I mentioned at the top of the show that Mark McKenna, professor from Notre Dame, who we're fortunate enough to have here with us today, is near and dear to the Star Athletica decision because a brief that he authored was actually cited in Justice Breyer's dissent of the case. Did that take you by surprise at all, Mark?
Well, obviously, it's nice to be cited in a Supreme Court opinion. It's better if it's in the majority than in the dissent. I mean, obviously, so I should say first that I didn't author it by myself. I was co-authored with Rebecca Tuchneck, Chris Sprigman, and Mark Lemley. So, it's a really hard question, one that has bedeviled courts for decades. And what we were trying to do in the brief was to bring it back to first principles and help the court understand what Congress was trying to do when it created the useful articles doctrine and the separability concept. I think it's pretty clear if you study the history of that what it was trying to do was to differentiate industrial design on the one hand from applied art on the other hand, and to send industrial design to design patent and allow copyright only for applied art. Of course, you can say that in principle, but then you have to operationalize that, and it did so through language that I think wasn't especially clear, and I think that's been the source of the problem. So I have to say I don't think the Supreme Court improved that situation in the majority. I think Justice Breyer's opinion, and obviously I would think this since it it borrows from our brief pretty heavily, but I think it highlights pretty well the flaws in the majority opinion, and I think the difficulties that courts are going to have. What I do think is probably going to happen as a result of the majority opinion is it's going to push most of the difficult questions from separability over to originality, because I think the Supreme Court made separability a much easier standard to meet. But courts are still going to very strongly have the impulse that some of these things don't deserve protection, and it's going to have to think about the outlet of that for that being originality, idea expression, dichotomy, merger doctrine, that sort of stuff. And I think the Supreme Court sort of indicated that. It said, we're not deciding the ultimate copyrightability of these features. We're just deciding that they're separable. So I think the effect of that decision is yet to be seen until we see how courts actually implement it and how they react to it as a matter of other doctrines.
Right. And I just, this has nothing to do with the case, but I just wanted to tell you what a warm little glow I got when you mentioned your co-authors, and I realized we have a quadfecta because we've now had all of you on the show. So yay.
Well,
yay,
yeah,
TWiL.
you had some other good guests then. So
yes, very much so. So the news in the case is that the case has actually settled, and it has settled over the objection of the defendant in the case, Star Athletica. Can you tell us a bit about that, Mark?
Yeah, so I mean, it's all the news stories I saw about that described it as unusual, and I think it probably is unusual in some sense. I mean, so Star Athletica's insurance company was paying for its legal defense. It wanted to resolve the case. Star Athletica did not, and they wanted to keep litigating. I presume because these guys are repeat players, and Varsity Brands is the big elephant in the room and dominates that market. And they know very well that if they settle this case in the future, they're going to want to make other cheerleading uniforms. And I suspect what they wanted was they wanted a definitive sense of which aspects of, or if any, of these designs were actually protectable in the end, and what scope of protection was attached to them, so they knew how to behave in the future. And I think that was the reason why they didn't want to settle, and they wanted to be able to litigate this all the way through to a judgment. And the insurance company's interests are obviously a little different there.
Right. So they told the court, I think, in fighting the settlement, that they had alternative routes to attack Varsity's copyrights. Is that what you're discussing? Is that what that would have looked like, do you think?
I think that's what I was suggesting before. My very strong suspicion is that when the case was relitigated in the lower court, what was going to happen was that Star Athletica was going to say, fine, these things are separable, but they lack originality, or at least whatever originality there is merges into the idea, and that the Supreme Court explicitly left that door open. And given that, there's only a small number of ways in which you can make cheerleading uniforms look like cheerleading uniforms, I think there was a reasonable chance of that argument winning. And that at the very least, what it would have done is force Varsity to describe the scope of its rights in pretty narrow terms. And if you look actually at the challenged designs that Star Athletica created, some of them were they were certainly not identical, and in my judgment, some of them were not even that similar, if you discount the fact that they're both using stripes and chevrons because they're cheerleading uniforms.
Mm-hmm. Yeah, the insurance piece is really fascinating. I think if people haven't had the opportunity to practice with a client who's been involved in a case, who's had insurance that may or may not apply in a company, an insurance company that's helping them or paying the full boat of their legal fees. And what I'm reading between the lines here, nobody's providing any details on it, but what seems to be the case, since they had so much control over whether the case settled or not, is that the insurance company for Star Athletica must have been providing that party a complete legal defense. In other words, paying all the legal bills in the case. And even though Star Athletica wanted to go on and use these other copyright related arguments, the insurance company had enough and said, nope, we've reached a settlement. We are paying your fees. We get to make that call. And the judge, U.S. District Judge Robert H. Cleland, agreed. Mike, do you agree with me that that's what is going on here?
Yeah, I think that's exactly what likely happened here. Mm-hmm. Depending on the type of insurance and the policy language, I've dealt with this a number of times involving intellectual property disputes. Sometimes the insurance language is favorable for the insured in that it doesn't allow the insurance company to step in and settle the case. Conversely, sometimes there are policies written that give the insurer the right to step in and settle a case at any stage of the proceedings. So I suspect that there was some language that the insurance carrier was seizing on, saying, look, we can step in and settle the case on your behalf, whether you like it or not. That's part of the insurance contract that you agreed to, and therefore we're going to step in and settle the case. So I think that's probably what happened. And it does look like there was some sort of, according to the settlement agreement, it looks like there was some sort of payment that was ultimately made, but
mm-hmm. But we don't know what that is.
We don't. It sounds like it's a confidential settlement between the two parties. Well, between the plaintiff and the defendant's insurance company.
Right. So Mark, do you think that this case left a lot of unanswered questions that are going to just, now they're set in stone? There's not going to be any further clarification from any court since this is settled on the issues here. Do you think that it sort of confused more than it solved?
Yeah, I do think it left a lot open, and I think we're not going to get more resolution in this case, but I do think that we're going to get a lot more of these kinds of cases because the resolution of the case, as I mentioned earlier, I think the kind of received wisdom of the case law prior to this case was that it was very difficult to use copyright to protect features of clothing. My read, and my sense is that a lot of people's read of Star Athletica is that received wisdom is no longer particularly true. So I think it's going to invite lots more use of copyright in these kinds of cases. But as I say, I think that's going to squeeze the balloon, and it's going to put more pressure on other kinds of doctrines that, and so you could imagine a couple of different kinds of responses to that. One is that the useful article doctrine becomes not much of a barrier to copyright protection, but that we get a more robust set of rules in originality and idea and the idea expression dichotomy dealing with these sorts of cases. As things stand right now, I mean, originality is not a very high bar to copyright, but in some categories of cases, idea expression has some bite, and it might be that this becomes one of those categories. Or it could be that courts are reluctant to push everything there, and they try to find some way to read Star Athletica to hang on to, something in useful articles. But I think it's going to take a while, for that to percolate around, and it's going to take several cases getting to different courts of appeal before we start seeing any kind of pattern emerge.
Hey, Matt, any questions or comments about Star Athletica's, the case itself or its settlement?
No, I think that Mark and Mike covered it well.
I know that they did. All right, then let us move on and look at some stories under our heading Crimes and Justice. Mike, we were going to talk about this one last week, but we saved it for you. I think it's fascinating, even if you're not in Washington State. And of course, probably many of you are, so it's particularly fascinating for you. But Washington State has enacted not just a driving under the influence law that affects to your impairment from some substance, but it has enacted one that impacts your impairment from your devices. Can you tell us about this?
Yes. So my understanding, it's the first law of its kind. It's called Washington's DUIE law, which prohibits driving under the influence of electronic devices, hence DUIE. And this is just a little bit of background on our law here in Washington. It has been for the last 10 years or so, it has been prohibited to use a cell phone holding it to your ear while driving. This law goes a step further and says you can't use a device at all while you're driving. Even if you're stopped at a stoplight, you can't use a device. And it is a primary offense, meaning that if you are spotted using your electronic device, you can be pulled over for that alone. It's something that you can be cited for. Now, it doesn't carry the same type of penalty as a DUI. This is a civil infraction, but it will be reported, as I understand it. It's something that would be reported to your insurance company. So if you do get cited for a DUIE, it could result in insurance rates going up. And the other thing is just using the device itself. I mean, there is an exception for, I think you could use a single finger to operate the device to hit a button on the device, but that's it. Anything above and beyond that, that is an offense, and you can be cited for DUIE in Washington.
But just to probe deeper on this, if you have something like Apple CarPlay or anything that connects your phone to your car and allows you to use it from a button on the steering wheel to talk to it instead of look at it or touch it, is that carved out?
My understanding is that is carved out.
Yeah.
Hands-free type of interaction with an electronic device or another component of your vehicle is still okay under this law. I should also mention that there's another provision in this new statute that potentially makes it a secondary offense for eating and grooming oneself. So if a law enforcement officer believes that you are distracted as a result of personal grooming or eating, you can be also cited for that. But as I understand it, you can't be pulled over for grooming or eating. That would be a secondary offense that you can be cited for once you are pulled over. So if you happen to be using your cell phone while you're grooming or eating, you've got potentially 3 different offenses you can be cited for. So look out if you come to Washington.
Or if you had a tail light out and you were also mowing down on a hamburger, you could be cited for both things, presumably, right?
That's right. Yes,
Oh
the
my
combinations are virtually endless here.
Oh, I love it. I feel like it was the eating or grooming thing that they really wanted to get past, and that they just tacked it on to the devices thing so that it had some semblance of, pass muster credibility.
could very well be.
Is there an exception if you're only eating your hamburger with one finger?
Oh boy, that's probably going to raise some interesting statutory interpretation. Yeah. Matt, I don't know that there's the one finger exception with respect to eating or grooming.
Only for the phones.
Only for operations of a electronic device.
Is it carved out if you have connected your hamburger to your car and you are able to virtually enjoy it rather than actually touching it? Only your senses of smell are involved, or perhaps it's being delivered hands-free to your mouth.
That sounds like an excellent law school exam.
I'm sorry, I'm having way too much fun with this one. Mark McKenna, do you have any serious or otherwise response to the DUIE law in Washington State?
So I obviously don't know much about the law, but I would say I teach torts, and driving while texting is a very significant cause of most of the injuries now, and so I think that's replacing drunk driving as the example that everyone uses because it's so common. And then I'll just also say another thing that goes away when we have self-driving cars.
Yeah, definitely. Some of these laws will become obsolete. Matt, any thoughts?
Yeah, just that these sort of laws are difficult to challenge. The vagueness of the whether you're using a single finger or two fingers. I would not want to be the cop who has to testify to that. I feel like that would get old. But otherwise, it's gonna uphold, and you're gonna have to pay your fine.
Right. We have more topics to get to, but just to go down a small rat hole here on the topic we're on, since you teach torts, Mark, and since we brought up just now the topic of self-driving cars, I'm wondering, we could do a whole show with you on that topic, no doubt, but I'm wondering how or whether you're going to incorporate liability issues or reduction of liability issues, reduction of safety problems, or maybe the introduction of new ones as self-driving cars become more and more prevalent.
Yeah, so if you do want to do an episode on that, the person you should call is Ryan Kalo, who's at University of Washington in Seattle. He's actually got written a whole bunch of things about self-driving cars and is one of the experts in our field. But so, I mean, one of the themes when I teach torts has to do with the way that the law deals with new technology and the way that it winds up affecting either settled rules or doesn't affect it, and we try to apply it. I mean, so if you look at most of the way that tort law is built in American American courts, it's basically about trains, which were sort of rumbling through the countryside and destroying everything in their path. And so there's there are a million of those things, and then cars replace them as the things that are most likely to cause problems in there. So you can see some adaptation from train cases to car cases, in part because they're of decentralization. A lot of the railroads were monopolies, or they were at least regional monopolies. And you could see courts struggling with the question of, like, how much liability do we want to attach to trains? Because we really like trains. They actually help in a lot of ways. And so we might want to limit their liability. And then cars start happening, and you have sort of people intervening. So I do think that, the sort of evolution of technology is always thick on the ground in torts. In the self-driving car thing, I mean, I think actually there's a whole different, you can't really do much of this in 1L class, but there are a whole bunch of different levels on which they'll affect things. On the one hand, if you think about it from a product's liability standpoint, and you're asking yourself, what's the liability of the entities that produce self-driving cars? Self-driving cars are basically computers, and software. Tort laws had a hard time figuring out what to do with software, whether you treat it as a product or not, and and if a car is basically just a robot, there's some interesting things that are going to have to happen there to figure out whether and under what circumstances any product's liability. But then there's also the question of, to what extent does the driver still bear any responsibility for what happens with his or her self-driving car, especially in the intermediate period where we're going to have self-driving cars that have manual override possible? And then what will that do to the insurance markets? Because right now, insurance companies insure you as a driver. That's affected to some extent by what car you have, but it's you that they're insuring, and it's your risk factors. I know this because I have a teenage son, and when he became a driver, our bill changed pretty radically. But when you're not doing the driving anymore, someone else is doing the driving. What are we insuring? Are we insuring the vehicle? Are we insuring you as the owner of the vehicle? All that stuff's going to have to get worked out.
Yep, it sure will. And I think we have our second passphrase for the show for MCLE purposes, and it's going to be hands-free dining. So hopefully you've noted those down if you do intend to apply for CLE credit in your jurisdiction. Oh, and I've neglected to mention that we do have some more information for you about that if you're interested in doing so. If you head on over to wiki.twit.tv, find our This Week in Law page there, you'll find a handy-dandy chart that we have assembled that will help you in making an application in your jurisdiction if you enjoy our show and find it educational and think that CLE might be available for you under the rules that govern you. So let's see, we're in crimes and justice. We're talking about cars. Oh, we have a development in the HiQ LinkedIn case that we've discussed on the show. I think it was just last episode. The one that involves the Computer Fraud and Abuse Act being invoked by LinkedIn against a company called HiQ, which has been scraping its public website for data that HiQ wishes to use. It is publicly available information, so it's information that HiQ or anyone else could get if they wish to just put eyeballs on a page and copy down what was there. But rather than do that, they're actually using technological tools that basically do the same thing in a speedier way. Because LinkedIn, which is owned by Microsoft incidentally, had told HiQ not to do it, there's a case in the Ninth Circuit that they were relying on to say that means they now can't do it, and that we've done. It's now an unauthorized use of our computer under the Computer Fraud and Abuse Act. A judge now has disagreed and found that LinkedIn, and again, this is why I mentioned Microsoft, is because I don't know if the judge is remembering various other unfair competition and unfair market power cases involving Microsoft as a company, but the judge here raised concerns around LinkedIn's unfairly leveraging its power in the professional networking market for anti-competitive purposes. This is nicely written up at The Verge, and I think also at Ars Technica and probably elsewhere on the web. And of course, it's in our discussion points for the show if you want to pull up what we've reviewed to talk about it here today. They compared LinkedIn's argument to allowing website owners to block access by individuals or groups on the basis of race or gender discrimination. LinkedIn, for its part, said it was disappointed in the court's ruling and that the case goes on. There's been a preliminary injunction issued that says that HiQ can continue to scrape while the case is pending. And in order for a preliminary injunction to issue, we like to remind people whenever we're talking about preliminary injunctions, there's a pretty high standard that the party seeking that has to meet a reasonable likelihood or a high likelihood. Mike, litigator, remind me of success in order to get a preliminary injunction before a case is over. So they in this judge's mind have met that standard, and they're going to be able to continue doing what they're doing. Mike, you want to expand for us?
Sure. So you're right. Getting an injunction in federal court, it's not as easy as it used to be, at least in the context of intellectual property disputes. Which this isn't necessarily an IP dispute in terms of trademark or copyright, but it's close enough for purposes of the injunctive or what's being asked for in terms of injunctive relief here. So it requires that you show that you're likely to succeed on the merits, and that there's irreparable harm that will be caused without the injunction being issued, and that it's ultimately in the public's interest. So I think this decision is quite interesting in a number of respects. One, the injunction itself, normally we think of injunctions as stopping a party from doing or engaging in some act. And yes, true, LinkedIn is being stopped here, but what the court is allowing to go forward is this scraping that is allegedly in violation of the terms of service and a violation of the Computer Fraud and Abuse Act. So it's interesting in that respect. I also noted that the court found that no bond was necessary. Typically, under Rule 45 of the Civil Procedure Rules, for getting an injunction, a court must issue a bond or must require a bond. And it's not that there weren't arguments that there was harm here, at least as far as I could tell, reading the court's order. So I thought that was pretty interesting that no bond was required whatsoever. And then really the meat of the dispute here is, as near as I can tell, is under this Computer Fraud and Abuse Act. And I think this is a pretty significant departure in one sense from prior Ninth Circuit opinions that dealt with Computer Fraud and Abuse Act, because that statute prohibits unauthorized access to a computer system. And a party's access can be unauthorized if they are put on notice that they no longer have authority to access that particular system. And they were put on notice here that they no longer had authority to access LinkedIn, even the publicly available data. So it's interesting for the court to look at it. And as I understand the court's ruling, ultimately what the judge said here is, look, even though there's a couple of cases out of the Ninth Circuit that would seem to support LinkedIn's argument, those cases dealt with data that was not publicly available. All of this information that's being scraped by the defendant here deals with publicly available information that anybody logged on to LinkedIn could have access to. So really interesting case. As a denial of as a granting of a preliminary injunction, it will give LinkedIn and Microsoft the immediate right to appeal this. It'll go to close to the front of the line in terms of the appellate process. So we'll see if they do that. And we'll see what the Ninth Circuit ultimately does with it.
Right. Fascinating. Thanks for that, Mike. Mark, any thoughts about this?
Yeah, I'm not a CAFA expert, but this question about what counts as unauthorized access has been one that's been pretty hot on the ground. And the rule that some courts had established before, that basically unauthorized access means any access that's against the permission of the website holder, even if you don't use any technological means to hack the site, which is its most extreme version would just mean any violation of the terms of service is a CAFA violation. That's been really controversial, and I think for good reason. And this, I think, is obviously it's early, and we'll have to see whether it stands. But if courts are going to start pushing back on that, otherwise, what it risks turning CAFA into, remember that CAFA's got criminal sanctions in it too. It's not just civil. That making it a criminal violation every time you post something in violation of the terms of service on Facebook. Actually thinking back to our earlier conversation, in theory, Facebook, under an extreme version of that argument, if Facebook's terms of service say you can't post, white supremacist material on there, that's subject to criminal liability if they do it. So I think most people who, at least academics who work in this field, felt like that was an extreme position, and at least in my circles, which I grant are probably skewed versions, but in social media, most people were celebrating this decision as a step back towards sanity. But I do think it's important to note that in part that the distinctions most of those people were making was that CAFA was meant to be about computer hacking. It was meant to be about people using technological means to get access to things that weren't publicly available, and so that distinction the court makes about the fact that this stuff is visible and public and and unauthorized only because we told you not to, is a distinction that I think a lot of people have been arguing for.
Right. And I think you were alluding to a minute ago, maybe among other things, the Lori Drew case where the woman was prosecuted under the Computer Fraud and Abuse Act for using Facebook in a way that violated its terms of service when she cyberbullied a girl who ultimately committed suicide. So it was a terrible case on all sides, and one aspect of it was the very broad application of the Computer Fraud and Abuse Act to prosecute the woman who did the bullying there in that case. Matt, anything you would like to ask or add?
Yeah, just again, that as I mentioned last week, the case that LinkedIn was trying to rely on was the Power versus Facebook, where Power.com was actually publishing information on individuals' websites. So I was glad that the court distinguished between those two cases. And I did think it was interesting that the judge related this to deprivation of minorities' rights. I guess I don't really see how they get there because they did this more from a business perspective. So it'll be interesting to see if that's that part of it and that language is extended.
Right. I wonder, I haven't read the ruling yet. So I'd like to see if the judge expanded on that and gave us some more insight into the thinking there. But I wonder whether, since it's, denying access to things that are publicly available on the web, if what the judge was sort of hearkening back to is, I think we cited Oren Kerr talking about, he gave an example where maybe CNN could tell competing news networks, you may not, view the material on our site, thereby blocking them. Right. And that would be, an extreme use of the statute that Congress probably didn't intend. I'm proud of us so far on the show. Everyone we've name checked today has actually been on the show. Ryan Kalo's been on the show, Mark, so you'll be glad to know that. And now I'm going to name check Amanda Lewandowski, who we've had on as a guest, who tweeted, interestingly, if you care about using scraped data for training AI systems, which we talked about a lot last week, you should pay attention to the injunction in HiQ versus LinkedIn. That's one purpose that scraped data could be greedily used for, as the AI systems or neural nets gobbled it up and spit out interesting paint colors or law firm names, as Emory trained one to do. Any thoughts about that, Mike?
I'm sorry. I didn't mean to interrupt. I was
go
just
ahead.
Say, since we're name dropping, I just actually, Amanda, I was just at a conference where she presented a paper about training AI systems. And actually, I think that's a very important point she's making, which is that, AI systems, insofar as their input for their training is skewed, and one way that it might be skewed is that there are things that are that the systems are told are off limits, even though they're publicly available information. Bad inputs make bad outputs in the training. And so it's a serious point she's making.
All right. We have a perfect record to maintain for the rest of the show here, gentlemen. There's a really interesting case that I think we'll get to next week. The DreamHost controversy about the subpoena that they were served with, and to what extent they have to comply with a government subpoena asking for information about visitors to a website that DreamHost has objected to and thinks is quite broad. I think we're going to save that for next week, because I really, I've been shelving now for 2 weeks the discussion of Star Trek coming after the Dr. Seuss Star Trek mashup, the other foot dropping in a case that, or other shoe dropping in the case that we've discussed before. So we're going to get to that this week. And if to do that, we're going to discuss one or more decisions involving Hollywood music and entertainment. Mike, I couldn't let us not get to this week. So
I'm so glad you waited.
Yes, you can do this in verse or not, per your preference. But just to remind people, there was a dispute between some folks who call themselves Comic Mix, who include one of the scriptwriters for The Trouble with Tribbles, various people who were at one point or another involved in the Star Trek franchise, but who have moved on to do other things. And they did a mashup called "Oh, the Places You'll Boldly Go," that depicted Star Trek, very identifiable Star Trek characters like Mr. Spock, for example, drawn in a Dr. Seuss fashion. And of course, the thing is done completely in Dr. Seuss style verse. There is a lawsuit pending from the Dr. Seuss side of things that Mike has very nicely summed up on their blog at Dorsey, the TMCA.com, in verse. But it moves forward. And one of the things that has happened is the complaint has come under fire a couple of times. There has been a second motion to dismiss filed, the new amended complaint. And one of the things that came out there, although they're not a party to the lawsuit, is that CBS and Paramount had actually weighed in on this too and sent a cease and desist to Comic Mix. So I know you've read the new motion to dismiss, Mike. What can you tell us about what's going on?
Right. So what happened as a result of the court's initial order is Dr. Seuss Enterprises had amended the complaint to not only flesh out some of the copyright aspects, but also amended it with respect to the trademark claims to add in additional facts, anticipating that a second motion to dismiss would likely be filed by Comic Mix. And as you mentioned, it was. They filed it last month. The response to that motion to dismiss was just filed within the last couple of days, and it looks like a hearing is set later this month. So this is moving pretty rapidly here. So what happened as a result of the court's initial order is the court dismissed the trademark claims under this doctrine of nominative fair use. And with respect to the copyright claims, it really focused primarily on fair use and whether the defendant's use should be considered fair under the copyright statute. There are 4 factors, of course, involved in the fair use analysis, and 3 out of the 4, the court found that were in favor of the defendant. The only issue that remained was whether there would be market harm to the original work, and that's a question that the court ultimately found couldn't be decided on the motion to dismiss stage. So, as I mentioned, Dr. Seuss Enterprises filed an amended complaint. They again moved to dismiss. Comic Mix did, again saying dismiss everything because they can't prevail either under the copyright statute or under the trademark statute. So it's going to be great to see what happens. You know, this is an important case from my perspective because it deals with a cultural phenomenon of mashups. And, you know, I don't know that the law is super well developed in this area in terms of when is a mashup protected, when should it be protected. And so I think this is an important case, and we'll see how this goes. Hopefully we don't get an insurance carrier that steps in and settles the case before it's finally resolved. So yes. I am personally, as you know, watching this case very closely.
Yes. And I only have 2 things to add. That is, if you're in San Diego and you're interested in this case, as Mike mentioned, there's going to be a hearing on August 31st at 1:30 in federal court there. If you're interested to know how things go on the second motion to dismiss, court hearings are public. Why not wander in and entertain yourself for a while? Secondly, there is a point in the motion to dismiss. I did not read the whole thing. I sort of skimmed it. But there is a point where the moving parties challenged the amended complaint by saying the amendments are futile. Just leaving that out there for you in true Borg fashion. Mark McKenna, anything you'd like to add to the Comics Mix, Dr. Seuss, and potentially Paramount CBS dispute?
Yeah, so I mean, so I too am watching this case pretty closely. I think a lot of us are. So I think I agree with everything Mike said. On the copyright side, I think that it is an opportunity to get some more case law on the mashup. I think it's the interesting thing about Star Trek is that, it has these sort of what it thinks of as guidelines for like when fans can do various things and when they cross the line. And there's a sort of understanding. I'm not a Trekkie, so I'm not going to try to articulate them. But I think that we could get some clarification, essentially, of how that the fair use doctrine is going to play out in the setting of mashups generally, but especially also in settings where it's a sort of fan fiction thing. I think there's also a very interesting. I'm watching carefully the trademark side of the case too, for two reasons. One is there's an older case in which the Dr. Seuss folks sued over a book called that was about O.J. Simpson, and it was I'm trying to remember the name. It was something by Dr. Juice. I forget what it was called, but I have it in my office. That's why I'm looking around, but I can't see it at the moment. And the Dr. Seuss people won that case on a trademark grounds, in part because the court said this is not parody, it's satire, a distinction that is more significant in copyright in general than it is in trademark. It's not really a doctrinal distinction in trademark at all, and it's a distinction that had a particular moment in the spotlight in copyright, but I think is fading as the Campbell case settles in more and more over time. So my suspicion is that had that old case been litigated today, it would have reached a different result. But it's there, so I think that's sort of lingering in the shadow here and emboldening the claim. So as you said before, the court dismissed the original complaint on nominative fair use grounds. Ninth Circuit case law on nominative fair use is more robust than it is in other jurisdictions. It's still never been a crystal clear doctrine. I actually think there's an even sounder basis on which to get rid of this claim as a trademark matter, which is that they're really using trademark to police the content of a creative work. And there's a Supreme Court decision called Daystar versus 20th Century Fox, which is precisely about that. And to me, this claim can't survive Daystar as a trademark matter. It is and should be resolved as a matter of copyright law. I don't mean to say by that it should win as a matter of copyright, but that it's a copyright dispute. It's not a trademark dispute.
Yeah.
Yeah. Fascinating.
So Mark,
you agree, Mike?
Mark, I do agree with that. And the parody, or excuse me, the satire that Professor McKenna was just referring to is the cat not in the hat.
There you go. Thank you. It
was over the O.J. Simpson murder trial. And this came out back in 1997 or so, I believe. So, but yes, I do agree that this is not a trademark dispute as much as the Dr. Seuss folks are trying to make it one. I did note in the amended complaint and elsewhere in their filings that they're saying that parents could pick up this book and be confused and take it home for Johnny, thinking that it's a Dr. Seuss book when in fact it's not. That may be a bit of a stretch, but at the end of the day, really, this is about copyrightable content and whether a mashup is protected under fair use. It's really not a source identifying trademark dispute, or at least it shouldn't be.
Right. It's either an illegitimate derivative work or it's fair use, and that's the right question to ask.
Yep.
My final thought on this is I'm just sort of flabbergasted that we've been doing the show almost 11 years, and in those 11 years, there is not any more clarity in the law on this than there was when we started doing the show. This is still as much an open question now as it was then. Matt, do you have any final thoughts?
Yeah, just one thing. After we talked about this previously, one of our listeners wrote in and said that this book is typically sold for graduation and such. So this, in terms of the market harm analysis, that may not be good for the defendant, that this is typically sold to an adult consumer, that if they're a Trekkie and into this, that might hurt their case.
Yep, good point.
Yeah, I mean, one of the things that always is lingering in any fair use case, and I think will come up in this case, is there was a conventional wisdom for a while that market harm factor was the big thing. That was the thing that was going to drive the cases. But I think increasingly courts have recognized that there are certain kinds of cases where market harm is not, it's at least not the entire question, and maybe not even the central question in cases that really are involving transformative uses of the work. And so that the trend line away, I think there's a bit of a trend line away from resting the whole case on the market harm question, in part because it can look like it swamps other important considerations in the case. Like, does this look like a really significantly transformative thing where someone's making their own speech?
All right. Well, I'm so glad we finally got to that story and those topics of fair use in this particular dispute, and how it may, as Mike hopes, and I'm sure we all do, provide some more clarity to the state of the law regarding mashups. Right now, we're going to get to our treats that we leave for you at the end of the show, useful tidbits that we hope you can incorporate in your own life and enjoy or benefit from. Number one this week will be our resource of the week. And since we've been talking a bit about trade secret law in the and what happens when employees leave and take trade secrets with them, in the context of the Waymo and Uber case, this is a particularly topical little tidbit to throw your way. Really great little tool. Just off the top here, I want to mention that I have nothing to do with Seaforth Shaw, the law firm. No axe to grind or getting no benefit from them and plugging something that they have published. But it's a really useful little chart here by two Seaforth Shaw lawyers, Michael Wexler and Robert Milligan. It is their 50-state desktop reference, what businesses need to know about non-compete and trade secret law. And what it is a 50-state, state-by-state chart for the U.S., obviously, talking mostly about non-competes. And it tells you the categories at the top of the chart are employee non-competes allowable? And that varies state by state, and they tell you where they are and where they are not. California falls into the not category with few narrow exceptions, as they point out. Then the next heading is state statutes governing employee non-competes. So they give you all the relevant law, or if there is none, they point that out for you. Are employee non-solicitation agreements allowable? They tell you state by state. Are customer non-solicitation agreements allowable? Again, they do the same. And continued employment sufficient consideration for having entered into a non-compete. And they will tell you one by one. So very quick, handy guide. Since the law on this topic is all over the map, it is really nice to have it all laid out in one place. Mike, do you like this thing?
Yes, great resource.
Very handy. Yeah. Okay, and then our tip of the week, hopefully also helpful for you, if a little bit sad, I gotta say. There was a study, and I don't have it pulled up, so let it load here quickly. It was published in the Social, Psychological, and Personality Science Journal. It was done by professors in Ben Gurion University of the Negev's Department of Management and the Guilford Glaser Faculty of Business and Management. And it goes to the topic of emoji law that we have talked about somewhat recently on the show, and is a fascinating and developing topic. And this study would be the kind of thing that you might see an emoji law expert come into, or an emoji impact or interpretation expert come into court and testify about. And what they did was they ran some experiments to see if you included a smiley in a business-related email, whether that was going to have the same kind of impact as if you were face-to-face with a business colleague and smiled at them. If you're face-to-face or via Skype or what have you, if you can see the person, smiling at them increases your giving off an air of competence and warmth. But including a smiley, it turns out, if you don't know the person at all and are having sort of arm's length conversations with them via email or text, including a smiley actually takes away from your credibility. They found in their experiments, the participants who they polled and asked about these things, takes away from your credibility, your perception of confidence, and makes you seem, you're more likely to be perceived as a woman interestingly enough, if you put a smiley in your business communications. Again, you can pull this up from our discussion points available at tagpacker.com/user/thisweekinlaw, episode 396. I encourage you to check it out. And their final guidance on the point is, for now, at least, a smiley can only replace a smile when you already know the other person. In initial interactions, it's better to avoid using smileys regardless of age or gender. So just a tip to pass along and bear in mind, and to add to your arsenal if you are building your resources of how to represent clients in the context of emoji law, how their emojis may come back to haunt them or be interpreted in contract interpretation or otherwise. File this one away, because you may need to get in touch with these scholars. Then finally, we will leave you with our animal selfie of the week. So, Mike, you didn't get to be on the show when we discussed the settlement of the Naruto case, and I know that that's killing you. Is there anything that you just need to get out there about the settlement, about PETA, about animal selfies and the copyrights that may or may not exist therein?
I don't think so. I'm still in a deep state of mourning over the whole settlement. So, we probably won't get a Ninth Circuit decision, which we were all looking forward to. If for no other reason, I was going to look to pen a poem for Naruto. But
yes, an ode. It would have had to be.
Right.
Yes, exactly. Well, as a consolation, I did not realize that this must have been, what's the date on this? June 21st was actually National Selfie Day. And how did we let that come and go without acknowledging it till August here? But the folks at We Rate Dogs did not let it come and go. And in fact, they put up a post asking, for National Selfie Day, please reply to this with your dog's best selfie. The picture must be taken by the dog. I can tell if it's not. So right there, we get into the issue of whether the animal took the photo or not. And if so, does that change the legal analysis? But in the meantime, of course, We Rate Dogs is one of the best loved Twitter accounts out there, I think. And this is some of its best work, getting people to submit animal selfies. Some of them you can tell, at least in some, an animal's paw is extended, like it might be pushing the button on the camera or GoPro pointed at it. Some were clearly taken by a human, so I think they would have to be out of the running under these criteria for a true animal selfie, but they are all adorable. So 13 out of 10 would litigate again. So there may be some other IP issues that come into play here. Of course, this and maybe they relate to fair use, the fair use discussion that we've been having, is that the whole way that this Twitter account exists is people submit voluntarily their animals' selfies to be featured on the site. And in fact, I'm sure eagerly await to see whether their submitted photo gets the nod to actually be featured on this very popular site. So adding a different layer to whether an animal can hold a copyright or not, what are the ramifications when you or your animal submits to a site to then be reshared, and maybe the site does a book of them and sells the book, and we could go down all of the IP ramifications of that. What do you think, Mark?
I think these sites are pretty fascinating in what they reveal about people, but they're also I think you're right that I think you're right, though. I mean, I would always say, these kind of sites, they also raise the really important question of are the people maintaining the sites, are they doing anything to monitor where any of this stuff is coming from? And obviously, to some extent they shouldn't. They want to say or take a don't ask, don't tell approach to it, but it also, raises some difficult problems. It also makes me want to put a picture of my dog up there. So,
of course, absolutely, I'm guilty. I have submitted a photo. My doggo did not get picked yet, but I hope springs eternal. But Mike, if you're advising these folks at Dog Rates or someone like them, I'm thinking they need to, at least have some sort of licensing dialogue with their lawyers, right? As they're taking in all these photos and reusing them.
That's
or
right.
Maybe not.
I mean,
yeah.
Just because somebody posts something online doesn't necessarily mean that a third party then has the right to reproduce that in a book or anthology or anything else. So that's right. You got to consider the scope of any license that was provided. So who knows? Maybe we'll see PETA issue a bunch of DMCA takedown notices as a result of all these doggy selfies. So.
It could be. It could be. Matt, anything to add?
Nope. I don't have a dog to add a picture to, but it's.
Aww.
See, I told you this reveals things about people.
Yeah.
That's right. Well, I know that at Dog Rates and others like to feature many wonderful shelters and places where we could remedy that for you, Matt. So,
all right, thank you.
Your options, the possibilities are endless, as I think Mike said earlier. So bear that in mind. Hey, this has been such a fun discussion. Mark McKenna, professor from Notre Dame. So great to meet you and have the chance to have this discussion with you today.
Yeah, great. Thanks for having me on.
Can you let us know? I know school is starting for you and Matt at Notre Dame next week. Is there anything, if we have listeners who are in your area, that you would like to let them know that's going on at the campus, or they could pay attention to, come and attend? Anything at all you'd like to plug before we get out of here today?
Yeah, we start school on Monday, and so all the 1Ls are rolling in right now, and I'll be seeing them in torts class at 11. I don't think anyone else probably wants to come to torts, but but there's a very active a set of things happening in the law school here and on campus all semester, and we'd be thrilled to have some extra people around.
Great. Wonderful. Good to know. Thanks so much again for joining us today. Matt, thank you so much for introducing us to Professor McKenna.
Yeah, no problem. Thanks for coming on, Professor McKenna. He is much beloved at the school, and I think that didn't get the chance to take torts with him, but everyone raved about him. So thanks for coming on.
Good. And you'll have the opportunity. What have you taken with Professor McKenna? Have you taken IP law yet?
Well, when you show up half an hour late to Skype calls or to signing up for your admissions class, you tend not to get Mark McKenna on. So I have not gotten him yet.
In the spring,
right,
I've gotten
right
in the spring. Yeah.
Yep. Bookmark it. Apply early and often.
Yeah.
Yes. Hey, Mike Keys, great chatting with you again this week.
Oh, man, this was so much fun. Great to be with all of you. And thank you, Professor McKenna, for carving out the time.
Happy to do it.
Yes, very much so. We just can't thank you enough. We do a really long show and we go deep on a lot of issues, and we know you have other things that you would like to do, but it's beneficial for us and so many of our listeners. We really, really appreciate it.
Anytime. Thanks.
What shall I tell you all at the end of the show? We will not be doing a show next Friday, but unlike next Friday, on most Fridays, we are here at 11 o'clock Pacific time, 1800 UTC. You can join us live. Please do join us live if you can. I mentioned the IRC chat earlier in the show. We have that going throughout the show. So that's at irc.twit.tv. And if you do join us live, you can jump in there and interact with us. Let us know what's on your minds during the show. Give us your examples of things that we discuss on the show, or your questions, or your legal insights, or your practical insights. We love having a live audience as we do the show. But if you can't do that, don't worry. Our entire archive of shows is actually available. If you go to twit.tv/TWiL, they are all just cataloged there for you. And you can go back and listen to the episodes with everyone we name checked today. Many of those people have been on multiple times. And hopefully that'll be the case for you, Mark, as well. Or whatever you would like. You can go back 11 years ago and see that we were talking about mashups, and we were just as confused about how the law would deal with them then as we are now. But again, hope springs eternal, and we're hoping for clarity and guidance and protection of an art form that so many of us know and love. What else can I tell you? So, when we record the show, you don't know yet, though, unless you've been listening a lot, because I ask you to do this at the end of every show. Please do get in touch with us between the shows. Give us your feedback on any and all fronts. My email is denise@twit.tv. Mike is mike@twit.tv. Matt is mattc@twit.tv. We'd love to continue the conversation with you. If you have further ideas, thoughts, questions about what we've discussed today, we'd love to hear from you about other people we can name check in the future and invite on the show who we've not yet had on, people who you've run across, whether in law practice or in scholarship or in the world, who you think would be interesting and educational folks for us to have on the show. We'd love to hear from you about that. And I particularly like it when people send me movie recommendations and book recommendations and all of the above, which lots of people like to do, and keep them coming. I love it. It keeps me in leisure time activity. So much obliged. And we won't see you next week, but we will see you the following week on This Week in Law. Until then, please take care.